An individual with drug history had an outstanding warrant for post-prison supervision violation. Now, the officers had this warrant in hand. They observed this individual walk into his house. They didn't make the arrest then. Instead, the officers waited 20 minutes, waited until the individual walked out of his house. But then again, they didn't make an arrest. Instead, they observed this guy get into his car and drive off. A few minutes later, officers pulled him over. They used what's called a box-in technique, where one officer parked in the rear of the vehicle, the other one in the front, essentially blocking him in and preventing him from fleeing. Now, this also meant that this individual couldn't park safely on the side of the road. Instead, he was now blocking the right lane of traffic. Now, if you've been paying attention to my channel, you know that a few years ago I published a series of videos called Vehicular Searches Without a Warrant, where I described and went into detail on all the exceptions that have been articulated throughout the years by the Supreme Court that dealt with vehicles. Now, if you remember, some of those exceptions are consent, automobile exception, search incident to a lawful arrest, inventory searches, and a few others. Now, today we're going to talk about inventory searches. Again, after you watch this video, go back and find that series. It is very interesting. Instead of going to one case, I give you a bunch of cases. I describe all of these exceptions. But today, the focus is inventory searches. Now, this individual argues that his Fourth Amendment rights were violated because the officers blocked him in and prevented him from parking the vehicle safely. And thus, they orchestrated the need to inventory search the vehicle. And on top of that, the officers later testified that they were trying to find evidence of a crime when they searched the vehicle. But I thought inventory searches were all about safekeeping the items. Now, before we go on, I want to thank you for watching me here on YouTube, subscribing to my channel. If you're new to the channel, hit that subscribe button. If you're a returning viewer, thank you so much for viewing one more time and sharing my channel with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to loststash.com and check out some of the merch, including these Do Not Arrest This Person t-shirts, hats, stickers, and some other items. And finally, if you'd like to hire me, I work in California. I'm also licensed in Nevada. I take cases both federally and state. So if you're interested, give me a call. Thanks for watching. Let's talk about inventory searches.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we're discussing United States versus Mark Johnson, and it deals with inventory searches. First, let's run through the factual background. I know I gave you pretty good information in the introduction, so I'm going to do it super quick. Officers have a warrant to arrest Mr. Johnson. They observe him outside of his house. They don't make an arrest. They see him go in the house. Again, they wait 20 minutes until he comes out. They don't make an arrest then. They wait until Mr. Johnson gets in his car, drives off, and a few minutes later, officers pull him over. Now, they use a box-in technique where one officer is parked in the rear, another one is parked in the front. It prevents Mr. Johnson from fleeing, but it also prevented him from parking safely on the side of the road. He's now blocking the right lane of traffic, so he's not safely parked. They get Mr. Johnson out of the car. They do a search incident to a lawful arrest. They pat him down. They find some of the items on him, including a folding knife and $7,100 in cash. Prior to impounding the vehicle, officers conduct what's called an inventory search. Inside the vehicle, they find a pipe with some white residue, 2 cell phones, and a jacket. And in the trunk of the vehicle, they find a backpack and a duffel bag. Officers later obtain a warrant to open up the duffel bag and the backpack, and they find some methamphetamine inside. Now, before I go on, I want to remind you that after this video, find my series that deals with vehicular searches without a warrant, because there I go through all the exceptions to the warrant requirement that have been articulated by the Supreme Court. So right now, if you pause this video, you can think about some of the exceptions other than inventory searches that might apply to this case. But here in the Ninth Circuit, because of how the case proceeded, we're only focusing on inventory searches. That is the only question that's presented to the Ninth Circuit. So now that the officers found methamphetamine inside the duffel bag and the backpack, Mr. Johnson is indicted on possessing with intent to distribute 50 grams or more of methamphetamine under 21 U.S.C. 841. He files a motion to suppress all the items that were found in the vehicle, saying that the officers violated his Fourth Amendment rights. He loses the suppression motion. He proceeds to trial. He loses there, gets convicted, and receives a 188 months sentence. So he now timely appeals and says that the lower court should have suppressed all the evidence that was found in the vehicle because his Fourth Amendment rights were violated. Now remember, the Fourth Amendment protects you against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct a search. But of course, exceptions apply, and today we're dealing with inventory search exception. As an exception to the warrant requirement of the Fourth Amendment to the United States Constitution, police may, without a warrant, impound and search a motor vehicle so long as they do so in conformance with the standardized procedures of the local police department and in furtherance of a community caretaking purpose, such as promoting public safety or the efficient flow of traffic. The purpose of such a search is to produce an inventory of the items in the car in order to protect the owner's property while it is in the custody of the police, to insure against claims of lost, stolen, or vandalized property, and to guard the police from danger. Thus, the purpose of the search must be non-investigative. It must be conducted on the basis of something other than suspicion of evidence of criminal activity. The search cannot be a ruse for general rummaging in order to discover incriminating evidence. Now that you know the definition of inventory searches, let's apply it. If you've been paying attention to my channel, and if you're familiar with other exceptions, one thing that should stand out to you. Usually, the subjective intent of the police officer does not matter. But for these administrative type searches, it does. Administrative searches can be deemed invalid if the officer's subjective purpose was to find evidence of a crime. Again, inventory searches are designed to inventory all the items inside the vehicle. It is not designed for the officers to go on a fishing expedition on finding evidence of a crime. So what does Mr. Johnson specifically argues? He says that the officers failed to make an arrest when he was outside of his house. Instead, they waited for him to get into the car. They used this box-in technique to get him in an unsafe place where he couldn't pull over to the side of the road to leave the car safely there after the arrest. Instead, he was blocking traffic in the right lane, and so he says the officers essentially orchestrated the need to impound the vehicle and conduct an inventory search. But Johnson's argument overlooks a critical fact that created the need to impound the car. Johnson could not provide the contact information for the car's owner. Johnson's inability to contact the owner could not have been orchestrated by the police, and without it, they may not have had reason to tow the car, as opposed to releasing it to its owner. In other words, the officer's chosen method of stopping Johnson would seem to be a poor way to orchestrate a scenario in which they would get to tow his car, unless they could have somehow known ahead of time that the car's true owner would not be available to retrieve it. There is no evidence that the officers were aware of such fact when they chose to pull him over. Johnson then makes a second argument. He says that even if the initial stop and the impoundment were valid, the search that preceded was not valid because the officers were trying to find evidence of a crime. He says that the officers were never trying to identify and keep the items for safekeeping, like what the impoundment and inventory searches supposed to do. Instead, he says that it was simply a pretext to find evidence of a crime. First, the arresting report prepared by Officer Corona stated that he believed it likely that the bags seized from the trunk contained evidence of restricted weapons and drug possession and sales. That he believed the seized cell phones may have been used to facilitate criminal activity and evidence may be found stored on the phones, and that all the seized items were placed into evidence. The affidavit Officer Corona submitted in support of his application for a search warrant further confirmed that the items had been seized pending further investigation rather than for safekeeping. And at the suppression hearing, Officer Corona specifically testified that he seized the 2 bags from the car's trunk to hold onto them until he could secure a search warrant because he believed that likely there was evidence of a crime inside the 2 bags. And even now on appeal, the government continues to say that during the inventory search, Officer Corona found evidence of a crime, and he placed those items in evidence room. This is not the place that we usually put items for safekeeping, says the Ninth Circuit. In this overwhelming evidence that's presented to the Ninth Circuit, the court says that it is clear that the officers had motivation and the intent to search the vehicle for incriminating evidence. They were never inventorying the items inside for safekeeping. It is simply, even if we look at the way they name these things, they keep calling it evidence room, evidence of a crime, and so on. They never talk about these items as simply for safekeeping. And because of these reasons, the Ninth Circuit says that all the evidence found inside the car, the duffel bags, the drugs, the phones, have to be suppressed and cannot be used against Mr. Johnson at trial. So now the case is sent back to the lower court, and if you've learned something about inventory searches and the subjective intent of the police officers, which matters in these administrative searches, I hope you hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to loststash.com and check out some of the merch, including these Do Not Arrest This Person t-shirts, hats, stickers, and some other items. Thanks a lot for watching. See you later.